It's the biggest entertainment industry we have now, right? Gaming, interactive entertainment. It's surpassed Hollywood, so everyone's looking at it from a commercial opportunity perspective. But as soon as you get a hot market, whether it's gaming or other areas of tech, then obviously you get the regulators looking at whether users are protected, and that's no different for gaming, despite the fun aspects of it. And data is a big part of that.
Welcome to Privacy in Practice, the podcast where we bring you the latest insights, practical solutions, and real-world stories from the world of data protection and privacy. I'm Kellie Dupree.
And I'm Danie Strachan. Privacy in Practice is brought to you by VeriSafe, your trusted partner in privacy and data protection. In this podcast, we dig into the challenges and opportunities in privacy compliance, from navigating complex regulations to building a sustainable privacy program that works for your business, not against it.
So let's jump in and get practical with privacy.
Today, we are very excited to welcome Alex Roberts to the podcast. Alex is a leading expert in technology, privacy, and cybersecurity law with extensive and specific experience in both the gaming industry and in the Asia-Pacific region.
Alex currently serves as partner and head of TMT in China at Linklaters. He also co-leads their gaming sector, helping clients tackle the unique legal and regulatory challenges in the gaming industry. Over the past 13 years in the Asia-Pacific region, Alex has worked with financial institutions, corporates, and fintechs in heavily regulated sectors.
We're very excited to speak to Alex about how organizations, especially gaming companies, but not exclusively, can navigate these rapidly evolving, complex tech and regulatory challenges in also one of the world's most dynamic markets. Welcome, Alex.
Thanks, Kelly. Thanks, Danie, for having me. And thanks for the whole VeriSafe team for having me today. Hopefully we can bring some of that innovation to the insights on the podcast for your listeners.
I hope so too. That'll be awesome.
Alex, we're really thrilled to have you. We're talking about a topic that blends law, innovation, and gaming, how privacy and data protection play out in the gaming industry specifically. To kick us off, why do you think gaming has become such a hot topic in the data protection and privacy sphere right now?
It's the biggest entertainment industry we have now, right? Gaming, interactive entertainment. It's surpassed Hollywood, so everyone's looking at it from a commercial opportunity perspective. I think we're at about $300 billion last year for the gaming industry, projected to continue growing by about 9% a year, which is not a bad growth rate, up to about 500 billion by 2030. So everyone is looking at those opportunities. But as soon as you get a hot market, whether it's gaming or other areas of tech, then obviously you get the regulators looking at whether users are protected, whether businesses in the long term are protected. And that's no different for gaming, despite the fun aspects of it. And data is a big part of that. You can't deny with AI going through gaming, as it is other industries, there is going to be data, whether you're looking to get gamers' preferences and other details about them, and then personalize the games for the greater enjoyment of the gamers, or just monetize with your partners, whether it's ads or other endorsement tie-ups. But the regulators are therefore looking to put a cloak of data protection, data privacy rules around the industry. And where I'm in APAC, that's no different to Europe and the US, I would say.
So the law's taking a bit of fun out of the gaming industry, I'm afraid. I think what also makes it challenging is gaming companies try to target players around the world, and the world is just becoming increasingly complex. If you just think about privacy laws, let alone AI and digital safety laws, there are so many countries that are bringing out new laws or updating their laws and really challenging trying to keep up with really unique requirements in some jurisdictions. So I think if you're the privacy professional at a gaming organization, there's continuous learning happening and trying to stay in touch with what you have to do in country X and what you should stop doing in country Y.
As you say, these larger gaming companies are really targeting gamers in multiple jurisdictions, and particularly with your geopolitics at the moment, there are greater restrictions on the free flow of data, hopefully to protect the consumers, protect markets. But for gaming companies that want to bring that data back to a central depository, for the analytics, for monetization, that can be an issue. And as you allude to, for those data privacy professionals, those that are in-house at gaming companies or other tech companies indeed. There's just a plethora of rules that they need to be getting their head around. What's really interesting in my role, looking across region, looking across the globe at these rules as they wrap around the gaming industry, is how there are similarities, I would say, which makes it easier for data privacy professionals to get their head around them. But there are also nuances, and that's definitely the case in APAC where I am. I think traditionally people have thought that data privacy rules are rather lax here, but that's definitely no longer the case, and you need to moderate a sort of global or region-based, risk-based approach to privacy compliance program to take account of those rules even here in the APAC region.
I think one place where nuance certainly shows up is children. And that's obviously probably a big issue for some of your clients. Is that something that your clients have to navigate? How do you verify all the different nuances of the different children rules?
Yes, yeah, okay, that's a great question. It's been a growing area. I think I've seen some really interesting surveys in this part of the world. Even Australia, for instance, has been taking the lead in looking how online safety is just so much more important for teens and minors in the gaming industry. I think there's some really unfortunate statistics around about a fifth of gamers saying that have been receiving over the last 12 months hateful and abusive language in these sort of text environments, and it's similar statistics in the US. So the regulators are really cognizant of that, and it's making it more challenging for the gaming companies to stay on the right side of those rules. They all have their users, their gamers' best interests at heart, I think, but moderating and helping people to stay safe in these digital environments, as indeed we hope our kids do when they're in the playground. You need safeguards, and that's one of the areas I think that gaming companies, indeed regulators, are really looking at the moment.
You mentioned that people have this misconception that in APAC the rules are more lax. Can you give us like a quick summary of where the law is on children's privacy across the APAC region? That's a very hard question.
I like a hard question. Just generally stepping back in terms of general application of privacy rules in APAC, may or may not realize that I think we're up to about 13 jurisdictions that have taken the lead from the EU, from the European Union, and cut and paste the GDPR, either wholesale or some of the best bits of it, into their own markets' privacy laws. So it's not a region with lax privacy regulations anymore. If you look at Singapore in particular, very similar principles as to the GDPR. And indeed, last year, we've actually seen very specific rules, but there the gaming companies and others are sitting up and taking note of them, where they're focused on how they should be managing children's data under the main privacy legislation, but in an enhanced way for any users, any gamers that are under 13 years old, for instance, with additional consent requirements, really looking out for those children with greater vulnerabilities in this space. As I mentioned with those statistics, it's hard to deny these days that there are others within these games that are abusing the rights and the functionality of these games.
How close are the various countries in APAC in terms of regulations? Are there lots of similarities? I'm asking specifically because I think organizations are wondering, what do we do in APAC? Can we follow a regional approach, or does it have to be granular because the differences are so distinct between each country that you have to follow a country by country approach, which will obviously take much more time and effort to get implemented?
What we advise our clients is to think about those markets which are really key to you. Find which market, whether it's Singapore, as I said, that has a lot of the principles from the GDPR. China, where I am, has GDPR plus with its Chinese characteristics, but find out what your high watermark across those key jurisdictions are, and probably use that as a baseline for your compliance program. For instance, an easy one for people just to visualize is different markets have different ages at which gamers are deemed to be children. So it can be 14 in Korea, whereas Australia, with its new code for protecting individuals' data in the gaming industry, uses 15, for instance. So there are variants like this. I mentioned Singapore before, 13, that you need to be aware of. You find your middle ground, your benchmark, and work from that. So again, there's nuance to be aware of when these rules are changing on a constant basis. So it's an exciting challenge to get to grips with, but it's not impossible, and you can roll out even a European compliant privacy program here in APAC with a bit of thinking and hopefully good advice from the right legal firms.
I think that's very good advice. Find the high water mark in the jurisdiction that matters most. In response to all of these changes, are you seeing more companies try to be more proactive than perhaps they might have in the past, choosing that high water mark, so more self-regulation perhaps, instead of response to regulatory action?
Yeah, it's a really good question, Kelly, and one that we grapple with clients that, again, have traditionally seen APAC as somewhere that they can run fast and break things later because the regulators haven't necessarily enforced as quickly, or it's still the case in a number of jurisdictions where the fines that are meted out, if ever, are still relatively low compared to Europe, for instance, where the fines have been very high under the GDPR. But I think a lot of companies with ESG and other initiatives that have really gone around the world since COVID also appreciate that actually gamers, their stakeholders, holding them to a higher standard of compliance, whatever the law is these days. There's just a greater expectation. So actually building trust in markets in APAC and doing the right thing is something that we see, particularly multinational clients that are trying to build a brand in the gaming space that they're taking on board and trying to be consistent with international quote unquote standards.
Kellie, I'm curious about other regions because there's a lot of focus on APAC at the moment because many laws are coming out, and it is quite an interesting region, I think, Alex, because I'm just trying to picture how different the laws could be in your region, comparing Australia to China, for example. But Kellie, in the US, online privacy in the children's sphere isn't necessarily new. How do you think organizations should react with the latest changes in the US? Anything they should be looking out for there, specifically in the online privacy space when it comes to children?
Oh my goodness, so much. I think the US is a mess right now. You've got, just as a quick refresh, you've got COPPA, which has been in place for a long time. That's a main federal law. It's enforced by the FTC. And in the last month, there have been 3 FTC announcements about COPPA. So they're still actively enforcing COPPA. So that's a focus very much for the US side of the house. COPPA, again, 13 is the age. And a lot of the COPPA suits, interestingly, seem to focus not only on, did you know you had kids playing your game and you didn't do anything about it or didn't meet our rules that you were supposed to meet because you knew you had kids on the platform. There's one that was about transferring data to China without notice and proper verification and whatnot. And there's also ones about deceptive. The FTC often regulates around like deceptive and unfair trade practices and marketing and things like that. So there's also been a recent settlement around that, having kids buy things they didn't know they were buying, things like that as well. But then there's this huge patchwork of US state things. And some of them are related to the US state privacy laws that are coming into effect that not all states have. Some of it is a design code like in the UK and Australia and California. And then there's also these like social media laws that are very specific to social media, but then others just are regulating harmful content or addictive content. And so I think it's a very vague, messy space right now for gaming companies. Alex, I'm wondering, do you agree with that summary? And are your clients tearing their hair out, or how are they handling it?
No, Kelly, I think it's a really good summary. And I think, for instance, where I'm in APAC or the US, we describe maybe in some jurisdictions, privacy legislation is not as advanced as in Europe, for instance, but there are consumer laws. There are laws around advertising, marketing, around payments. Unless you understand, even as one of the privacy professionals in an organization, unless you can collaborate with the lawyers and the operations team to really understand this web of rules that we have now around these digital ecosystems, it's impossible to be compliant. It's impossible to allow the business to run as fast as it could within these frameworks that the regulators, I think we would all agree, are rightly putting in place to protect those most vulnerable out there in the gaming space.
And Danie, do you want to give us a quick UK EU rundown?
Yeah, I'm trying to sort it all out in my mind. I think it is quite difficult if you have to approach these things at a global level, because in the EU, you have the Digital Services Act, and the European Commission has issued specific guidelines relating to children's online safety under the DSA. And then in the UK, just on the other side of the channel, we have the Online Safety Act, and there are children's codes out there. And in both those regions, very strict complicated rules around age verification and making sure that they are very accurate. And it's challenging to try and keep all those differences in mind, because what might qualify as an acceptable age verification method in the US might not fly in Europe, because in Europe it's about online safety, but there's a big focus on privacy still. So if you want to verify whether or not someone is a child, you can't just ask them to scan in a copy of their passport. That's not going to work. So you have to look at other technologies, and the European Commission is working on new technologies that could be used, but they've, for example, mentioned some tools that will be approved. So, for example, if you're using anonymous age tokens, so those tokens come from an ID, but you as the organization don't see the IDs, zero knowledge proof is similar to that. Or a double blind system where someone is doing the verification, but the organization can't see the actual ID and know whose data is in that ID. So if you're running a gaming company specifically at a global level, you have to be aware of all of these things. You have to get experts involved where you don't necessarily have the skills or experience, but you need to have a plan and a strategy to make sure that you're aware of what is required in each jurisdiction and that you're implementing the necessary measures in order to stay compliant, because we'll see quite big fines soon, I think. So you don't want to be the organization that is going to be the test case on some of these things.
Danie, I don't know if I can just chip in just on the UK there, just as it's my homeland, I feel an affinity to it. But I think it's been really interesting in the online safety space. Where obviously post-Brexit, the UK is trying to look very liberal, much lower level regulation compared to the EU, but actually in online harms, the UK is gold-plated and gold-plated again, saying it wants to be the safest place to go when you're online. And there's so many gaming companies are there. We're talking 33 billion pound industry. It's a small market on the global scale and with these superpowers around the world, but actually in the gaming space, it's huge. Global gaming companies want to be there, but that compliance requirement is so much higher. And the regulator has said very specifically, tech companies, gaming companies, yes, usually you get a bit of a free pass because you're always in startup mode, but in offer online harm, we are not going to give you that. And I do expect those fines to start coming very quickly.
Challenge with the UK's law is the applicability. We're very used to the EU tests where it's either you're established there or you're targeting goods or services or monitoring people in the EU. But as I understand it, the UK's Online Safety Act could apply even if you're not specifically targeting people in the UK. But if children are playing your games in the UK, then you have to comply.
Yeah, and that's the case for so many privacy regimes now and other rules in the digital space, which you have to be aware of the extraterritorial impact. I mean, a lot of the advice that we do for multinational rules for Shanghai is around extraterritoriality of the rules here, where the regulators have just cut and paste from the GDPR. And I think, unfortunately, the GDPR has been cut and pasted by many regulators around the world now, being aware when you're providing services or goods into a market like the UK, these rules will look to apply to you. And from a reputational perspective, even if you don't have assets in the market that could be enforced against, you just don't want to be blacklisted by a significant regulator like that in the UK. With the UK just come online, it's a huge issue that our clients have been looking at. How do you comply with these requirements to be highly effective when you just overnight you've gone from 0 to 100? And as we alluded to before, different markets have different standards. You don't want to overcommit in one where and then put yourself offside and lose potential users, particularly in the gaming space where I think Danie, you said before, we've got kids, they don't necessarily have full national IDs to meet some of these requirements. So there's some amazing statistics out there in this terms of statistics around how companies using third-party providers actually can get compliant a lot quicker and a lot cheaper, because service providers have been surveying these rules that have been on the draftsman's table for so long. They're actually being ready to go from day one. So a lot of clients that I'm working with are actually plugging in these ready-to-go services a lot more than you might expect.
So, Alex, talking about data subjects and their requests, it's quite a tricky thing for organizations to handle. You have to be very careful when you get these requests to make sure that you acknowledge them immediately, respond to them within the time frame, make sure that you honor the request, but don't necessarily put something in there that could become a problem for you down the line. Specifically, if it's an employee's request that they might weaponize and then use subsequently if you terminate their employment. But in the gaming industry and in your region of the world, what are you seeing? Are data subjects active? Or are you seeing deletion requests or access requests? What is the trend at the moment?
I think probably in line with the theme that as we've gone through some of these discussions, APAC has traditionally been a bit further behind, I would say. Individuals have been less active in making these requests or indeed trying to flex their muscles and their privacy rights. But we've definitely seen a marked change, and particularly where I am in China, with regulators, authorities, actually enacting new rules to give enhanced rights to individuals, and B, actually telling them to go out and use them. So when we had a refreshed civil code here in China a few years ago, the regulators were very clear with individuals that actually they should be using the rights that are enacted under that piece of legislation to actually go and help the regulators to moderate business and help with creating a level playing field for everyone, where some businesses have just been going out there and, as I think I mentioned before, just running faster than they should, a bull in a China shop, no pun intended. So that's definitely a trend that I'm seeing across APAC now, Singapore, Malaysia, other markets. We're just getting a lot more aggressive use of data access requests, and regulators actually picking up. In Hong Kong, we were working on one a few months ago with a regulator that actually picked up on the fact that a request hadn't been dealt with as efficiently as possible, and they were very keen for our client to make sure they rectified that as quickly as possible.
I'm curious, Alex, what you're seeing as the scariest litigation trends for your gaming clients, or the most unexpected, perhaps.
I think APAC here for our clients this is definitely an area of differentiation in terms of enforcement. So I think I mentioned before there's consistency to an extent across markets because of the influence, the Brussels effect of the GDPR. But I think APAC is a little bit on its own when you talk about enforcement compared to other markets where Linklaters operates in, that here it is very regulator driven.
Yeah.
Whereas in the US and the EU, I think we're seeing this constant torrent of class actions, but in APAC that hasn't really started yet.
I think that class action point is, I feel like that's one of the biggest changes on the US side of the house lately. And been a big one. And when I say unexpected, that's what I was alluding to, because these US lawsuits are coming up based on a very creative set of laws. There's the wiretapping laws, there's the Video Privacy Protection Act lawsuits. And of course, a lot of these lawsuits deal with collection of data via pixels or cookies or things. Have you seen changes in the way that your clients are handling data collection in response to all of these sort of whack-a-mole lawsuits, particularly in the US, but overseas as well?
Not necessarily changing what they're doing in their home markets, but just doing it more and doing it more consistently, because the threat, whether it's regulatory actions, and to be, although traditionally we haven't seen them anything but regulatory investigations here in APAC, that is slowly starting to change as well, which is meaning that the clients that I'm talking to are now also starting to adapt and think about class actions and making sure that they are aware of what is in social media and people are chatting about, so they can try and head off these groups of gamers getting together, whether they're encouraged by pesky law firms or not. It's still interesting in the Singapore market, I think, where it's still illegal for law firms via advertising services to help generate class actions. Lobbyists in industry have so far managed to block that, but I'm sure that will change as things move more to the US and indeed the German style, where we see a lot of these class actions coming down the track.
Another thing on the US side that we're seeing now in the litigation is the way that privacy notices are being, I don't want to say weaponized, but used by plaintiffs' lawyers, and I could imagine in gaming chats too. You say you're committed to privacy. You say you have really high standards for treating our data, and yet you had a data breach, and yet you shared our data with someone we didn't want you to. Has that changed the way you advise clients on how they write their privacy notices?
It has. We do a lot of work and watch a lot of these enforcement actions as they come through, particularly in Europe, but also the US, and then help our clients to adapt. You try and do it in the background and not do overnight changes immediately after an action, which then prompts someone like none of your business and these other activist non-profits that we have in Europe and other markets. But you can learn as a group of privacy professionals and adapt slowly. And obviously when you do other updates for games, for instance, and it's a good excuse to start updating your privacy policy, then you bring in these changes to give you more protection. Yes, that's something that we do a lot of advice on, and I would always recommend you just have to stay on the front foot as privacy professionals or in-house lawyers and keep adapting, because the rules are changing, but also these actions and the findings that come out from these actions are changing all the time.
I want to echo that what we see on our side with our clients is more regular reviewing of privacy notices to make sure that they're accurate, that they don't say something in there that they don't do also, because at some stage everyone just put everything into that privacy notice. And I think some companies who did it themselves were often guilty of just copying, pasting from other people's privacy notices and then inadvertently saying that they're doing something they're not doing, but also not being clear enough in their privacy notices about what is being collected and who it's being shared with. I think there's a lot of attention lately on making sure that you know who data is being shared with. And specifically in gaming, it's all online and there's ads and lots of third parties and partners involved. You have to be very clear internally where the data is flowing and is it going out to a service provider or to an advertiser or a third party. So you can't really update the privacy notice until you've done that data mapping exercise. It feels like all privacy discussions always end up going back to data mapping at some point, because I think that is really the foundation and it's something that many people really dislike. But you have to do that data mapping and figure out what data you have and who it's being shared with and how long you keep it and what organizational and technical measures you have to look after that data, because otherwise you can't really update your privacy notice accurately. And I've also found for multinational clients, you have to look at other things as well, not just the privacy notice, but also the terms and conditions. In the US, it's become very popular for organizations to put those class action waivers and binding arbitration clauses in big black font there to try and protect themselves against those class actions, but also checking the just-in-time notices so that if someone downloads something and does something, that there is transparency. And we're talking about the online environment, and you mentioned COPPA earlier, Kellie, but there was that huge FTC settlement between the FTC and APAC Fortnite, and I think it was about 520 USD million, if I remember correctly. And two of the big things there was that there wasn't sufficient notice. The parents didn't really know what was happening, and they weren't aware that they should consent, and consent wasn't necessarily obtained, even though the FTC alleged that the organization knew that children were playing these games and that they were aimed at children. And then also just the privacy settings. So we often talk about privacy by design and privacy by default in a European context, but there the FTC also raised the issue, for example, that children were playing these games, but their mics were automatically enabled. They could automatically chat. And obviously in the online space, you have to be careful with children because of bullying and children getting targeted. So lots of potential litigation risks because of all these laws, and a lot of effort required to make sure that you're complying.
I really like that point that you made around the supply chain and knowing who externally has the data and the contractual terms. We've been a huge amount of work in that space, particularly as people have been trying to plug in all of these funky AI tools and data sets that have been generated by AI models, but just adding service provider after service provider or business partners. But we're seeing cybersecurity claims coming down the track, and we're working on one in the US at the moment where actually we're working for someone who's fifth in the chain in terms of components and services, but the claim has come down to them now. And these are multi-million-pound claims when you would usually think you're a long way from the original breach. So being able to point to terms and conditions and technical security measures that you put in place to try and protect yourself is so important, because these breaches and claims are just inevitable now, I think.
And I like that point too, because one thing that I think can be tricky for clients from a cost and time and all the rest of it perspective is just the sheer amount of effort that needs to go into the contracting with your vendors and your sub-processors, and the due diligence and potentially the transfer impact assessment and whatever else that needs to go into that whole management, the vendor management process. And I think one thing I always say is exactly your point. When there's a data breach, you need the protection, or you need something to point to that it's one of the many things that these DPAs and other documents do. It's also looking at each other and trying to decide who's paying who for what and whose fault it was and all the rest of it.
I think that's right, Kellie. And I think it's really interesting to see how the privacy professional, the lawyer's job, is going from just the technical side, and whether it's drafting or due diligence, that communication piece is also so important, whether it's with the external vendors, so you can do due diligence so much more efficiently, but also internal functions. We try and insert ourselves as the external law firm in those internal meetings where the internal teams are talking to their ops teams, they're talking to the tech teams, because actually that communication and that change in skill set, I think, is becoming so much more important for those that are working in privacy. Everyone's crying about the fact that their jobs are going to be taken away by AI. You can still have a job if you can talk to other people and communicate effectively, as far as I'm concerned. And I think that's only going to become more and more important in this space.
In fact, I think at the moment AI is generating more work for real people at the moment, because someone needs to keep a tab on things. So we have the advantage of being externally built for many of our clients. So we sit in many of those calls, and it's interesting to see how much shadow AI is out there, because we do the data mapping discussions of our clients, and we look at all these vendors and tools, and then somewhere in a discussion, someone was like, yeah, but I normally just use X, Y to do this. And then everyone's eyes go open a little bit more because no one knew that person Y was using this tool, and they were using the consumer version. So they've trained some model on their confidential info, and then really shocked to find out about all of this. How could that be? Well, that's how these models work, and that's why you have to pay for the enterprise version or the team version, so that your data is kept secure and siloed from the models. So it's definitely a case. There's this ongoing debate about whether privacy professionals are the right people to regulate AI, but it's so difficult to just stick to privacy, because privacy is so data focused. And when it comes to the data, AI now plays a role as well. So you have to ask these questions. Why are you using these tools, and what do you have in place to protect the organization and the people out there? So definitely enough work for now for people in this space, I think.
Yeah, I think I've seen some statistics from IBM where, amazing, that 90% of AI tools that people are using in organizations have not been signed off by their COSEC teams. Yeah, just that quick, cheap app on the phone that makes it a lot quicker to do something on the bus home or whatever. But yeah, the risk is there, robust to see. Internal education needs to go a long way, I think, to bring people back online and using these enterprise versions that have had the terms and conditions negotiated and the due diligence done.
We handle data subject requests quite a lot for our clients, because we have this external DPO role, and we often see confusion also from the user's side. So sometimes they think that they've deleted their account and therefore their data has been deleted, which is not necessarily true. Just by deleting your account doesn't mean that your data is eviscerated. I think there's still quite a big need to educate data subjects around their rights, and just to be more careful and wise about their data. So there we find that we often have to coach the data subject a little bit when they're sending in the request, and try and figure out exactly what they want. Do they just want their account terminated or suspended, or do they actually want all their data deleted. Kellie, in the US, is there such a focus on that, though? So we have these state privacy laws, and they also have rights for data subjects. But do you think they're actively being used like they are in other regions?
Depends on, this one's very state dependent, but the one that I want to mention, the California Shine the Light Law, and that's been an interesting development because a lot of, back to our like class actions and things like that, people are making access requests under the Shine the Light Law and then using that to form their lawsuits. So yeah, I think that's definitely a particular risk at the moment in the US, particularly in California. And it's always a risk, right, with the data subject requests. You want to help the person, you want to help them understand, you want to fulfill your obligations. It's also hard to know who's making the request and why they're making it.
That's very interesting. Can definitely see lots of practical challenges arising because of that. What is the Shine the Light Law, just for listeners who are maybe outside California?
It's an older privacy law in California, and it has a broad access request. I think it was from like 2003, 2005, and it essentially allows individuals to request companies to disclose information they have about them. As a result of that, though, people are getting all sorts of information that then they are using to then launch additional potential lawsuits.
If I understand correctly, the reason why they're also using those requests is because the Shine the Light Law requires you to disclose with whom you've shared someone's data.
Yes.
So in other words,
Good point.
third
Yes.
parties for direct marketing purposes specifically. Yes, that's one way to find out where data might be going and then trying to figure out if that could lead to a wiretapping case.
I think also it applies to smaller businesses than the CCPA has those reasonably large thresholds in terms of revenue and number of consumers' data collected, whereas the Shine the Light Law is much more applicable to smaller companies as well. You might not think as a smaller business you have to comply with access requests, but you would under this law.
Alex, it's been really insightful. As we close, is there one piece of advice that you'd like to give to gaming companies navigating privacy globally? What would that be?
Hopefully people have taken away that even APAC is a complicated region now in terms of privacy. And when you're looking at a regional, a global privacy policy, challenges are just multiplied. And because of that, my top advice, I hope, is that you need to start early prioritizing privacy programs and really privacy by design. And I think we touched on it earlier. It's not just you on your own, it's you collaborating with legal, if you're the privacy professional, it's you collaborating with the ops team, with the tech team, with those that are doing the in-game design, as well as marketing. It has to be a multifunctional exercise if you're really going to stay compliant. And I think you should take comfort from the fact that you've got a lot of transferable skills that you can bring into other areas of the business as they're grappling with bringing in the opportunities, but also the challenges of using these emerging technologies. But again, you need to start early and give yourself a long runway to get these things right. That also means staying on top of the rules as they're coming out in different markets. Give yourself that lead time with the grace periods before these rules kick in. Sometimes in China, we only get 2 weeks grace time, so it's not quite long enough for anybody. But obviously in other markets, you get much longer periods, but stay on top of these developments as they come. And probably just as an adjunct to that, I would say, communicate all of this hard work that you're doing internally with your gamers, with your users, with your stakeholders, because I think building that trust in your privacy program can really be a competitive advantage for you in this day and age.
That's great. I really like that last point. As someone who has children who occasionally play games online, I think that's a very real, very important point.
Alex, thanks so much for joining us. It's been really insightful, really stimulating discussion. Lots of food for thought here, and something that we might have to circle back to you again to unpack a little bit further.
Thank you, Alex. Thank you so much.
Thank you both. It was fun for me too.
That's it for today's episode of Privacy in Practice, brought to you by VeraSafe. We hope today's insights help you navigate privacy challenges with confidence and clarity.
If you enjoyed today's conversation, be sure to subscribe so you don't miss out on future episodes. And we'd love to hear from you. Share your thoughts, questions, or suggestions for future topics. Send us an email to podcast@verasafe.com.
And to learn more about VeraSafe's data protection and privacy services, you can visit us at verasafe.com.
Until next time, best of luck in approaching your privacy challenges in a practical way.
See you then.